church annexation.
Okay, thank you. Anyone else? Besides those mentioned, are there any other agenda changes for this evening?
There are none by staff.
All right, hearing none, I would move to go into executive session for a conference with the town attorney for the purpose of receiving legal advice on a specific legal question under CRS section 24.6.4024B.
And the purpose of that will be to receive legal advice on the Ladastian Lutheran Church application and the application of federal law to that land use matter.
Could I have that section again? Because I'm going to be doing the first cut of the minutes. It was 24.6.
.402. And then in parentheses 4. And then in another parentheses B.
Okay, thanks.
Yep.
So we'd be looking for a second to that.
Second.
All right, I hear a second. All those in favor?
Aye.
Any opposed? All right,
Then we'll convene into executive session.
Do I need to go?
Stefanik, you'll head out into the hallway. And we need to find a way to record this in a manner that is not part of the perfect. Yep.
Matter of fact, I should probably put a sign out there that says executive session just in case.
Well,
I
and
think
Jennifer
lunch
will be able to let everybody know.
Yeah,
Yeah,
not to come.
for
in.
sure.
Thank you,
And then
Jennifer.
We make sure this is turned off, or how do
We
we
can.
do that? Correct. Yeah.
All
You
right.
can open the door now.
Okay.
I hereby attest that this recording reflects the actual contents of the discussion at the executive session and has been made of lieu of any written minutes to satisfy the recording requirements of the open meetings law. The time is now 6:58 PM and we can conclude the executive session and return to the open meeting. Town clerk, please hand the tape to the town attorney to retain for a 90-day period.
There's one more now that we've got the door open and everybody's inside. This is what we're
Having ethics
gonna now
training.
read and then move on to the next.
All right.
Yep.
The time is now 6:59.
Go up there.
The executive session has concluded.
really-
with formal
you're
actions
planning
taken in
commissioner and
executive
then
session.
When the next
The
agenda item
participants in
comes
the
down, then you're
executive
stepping
session
down. Then
were-
you're going up again.
Steps in is what you're saying?
Rob, I'm gonna have us announce our names again.
Say your name again.
Rob Dilty, Commissioner.
Michael Bertel, Commissioner.
Eddie Aragon, Commissioner.
Nicole. Go ahead.
Nicole Centeno, Community Development Manager.
Mike Sawyer, Town Attorney.
Mark Chain Planner.
Great. For the record, if any person who participated in the executive session believes that any substantial discussion of any matters not included in the motion to go into executive session occurred during the executive session, or that any improper action occurred during the executive session in violation of the open meetings law, I would ask that you state your concerns for the record. All right, seeing none, the next agenda item is our FMC, I believe.
I'm gonna call it process and ethics training. They're
Process
kind of
ethics.
two different things. Come on in.
You're having,
Hey, Mark.
how you doing? We're having process and ethics training right now. So you can, welcome to sit or you can hang outside and should be about 15 minutes, I'm thinking.
Thank you, sir.
We're not going to move forward without you.
All right, thanks.
Okay.
So every now and again, at least historically, we haven't done with this with the P and Z, but with the Board of Trustees. Every year or two, we kind of spend 20 or 30 minutes to go over kind of general rules of conduct and how the law prescribes that you do your job in order to empower you to be able to act appropriately as the planning and zoning commissioners and to help you on the fly kind of know what your rules are and how to proceed. Again, you know, the P and Z does have the right to have legal help when you need it. I'm not here very frequently, but if you see something come up on an agenda that you're like, I think we might want to have some legal help, you talk to Nicole. Nicole will talk with the town administrator, and you may see me show up at your next meeting. So just so you're aware, the mere fact that I'm not here on a regular basis doesn't mean that in situations where having legal counsel present is a benefit to you, that we can't make that happen. So with respect to holding an office, and you are officers of the town of Silt, you've been appointed to the Planning and Zoning Commission. I always like to start off by reminding people that under state law, you exercise your duties pursuant to a specific public trust. That is to say that you embark on your duties on behalf of the public and you agree to do so to execute those duties in conformance with what the law is. There is a fiduciary duty that goes along with that. And on rare instances, people who abuse the public trust and that fiduciary duty can actually be prosecuted for a crime by the district attorney and put in jail. So that takes really bad conduct, something I cannot imagine would happen here in the town of Silt. But I throw that out there for you that, you know, the duties that you undertake, they do have special meaning within the context of the law. And that if you ever had a question about how to perform your duties correctly, or something that you were worried about that could lead to liability, you do have the right to ask the town to provide you with some advice on that. So again, we're here to help. The duties of the P and Z, so code section 2-16-110, which is the section that deals with the Planning and Zoning Commission. It outlines your duties, and essentially they're everything that's allowed under state's statute for a Planning and Zoning Commission. And as a general rule, I guess I would say that includes developing plans, adopting plans, considering zoning and subdivision requests, processing changes to the town code related to the subdivision code and the zoning code. Those are all things within the core competency of the P and Z. And you are both statutorily as well as under the Silt Town Code, you are authorized to undertake those duties. I want to talk for a minute about the capacity in which you act. You as a P and Z do two things. In some rare instances, you make decisions, like the buck stops with the P and Z. Okay. I was able to quickly, in my quick search, I think I was able to identify three things. Site plan review, sign code, fence permits. There may be a few more out there, but those are the ones that probably come up in front of you the most often. And when you are making a decision about what somebody can or cannot do with their property, you are acting in what's called a quasi-judicial manner. And what that means is that you're kind of like a judge. So again, we have the town code. The town code has all sorts of standards and criteria, particularly related to zoning and subdivision matters, engineering criteria, planning criteria, some legal criteria. And your job is to take in evidence when you're the one making the decision. And to process that evidence in the context of what your code says, you should approve an application if it meets the following criteria. And that includes your staff recommendations, the staff reports, the application from the applicant, the testimony that's given by the applicant, public comment that happens, because usually when you're acting to actually make a final decision, it's a public hearing. There's been notice given. The public has the right to come in and to comment on the application. You take all that in and you're kind of acting like a judge. It's like, you're like, okay, Mark identified for me that here are the 7 criteria for approving an annexation. Okay. Yeah, well, that's a bad example. You're recommending that for the 7 criteria for a site plan review. And he goes through how he believes that the application satisfies those 7 criteria, and you hear from the applicant and the public, and you probably have questions of your own that you're gonna, hey, you know, what is this and how does it comply with our parking requirements, or whatever the specific issue may be. You bring that all together and you're going to make a decision, and it needs to be based on the evidence that was presented and what the criteria in your code are. That's more or less what a judge does. The judge takes the law, the judge hears evidence, facts, testimony, documents that come in, merges those 2 together, weighs the evidence against what the law says is relevant, makes a decision. That's why we call it quasi-judicial decision-making by you as a P&Z. What is critical for you to understand about quasi-judicial decisions and kind of public hearings in general is that you are supposed to make your decision limited to the information presented in the public meeting. Now, that can include the staff reports. I mean, nobody's going to read them line for line. They get introduced into the packet, which is brought into the public hearing. But what you're not supposed to do is to have a lot of communications with people outside of the public hearing, or to receive documents or information from persons outside of the public hearing, because the applicant has a constitutionally protected due process interest that they get to hear everything about their application and the right to respond to it. And if you get a bunch of comments outside of the meeting room, out on the street or at the minor's claim or wherever you may be, the applicant doesn't know what those comments are. It may have moved your opinion about how you think about this application, and affect how you vote. And the applicant doesn't know that, and they don't get a chance to respond to it. So you will find on occasion that when an application that has some controversy is brought in front of you, that people will approach you and they will say, Rob, you're on that planning commission. You're going to hear this matter involving this subdivision or this apartment complex or whatever it is that's going in. And you have to say, you're right, and I care about what you have to say, but you need to come to this public hearing and tell it to me at the public hearing, or if you can't come, put it down in writing and send it to Nicole and she'll make sure it gets to me. And that way, everybody, the commission, the staff, the applicant, and even the public that may be interested in this, everybody knows what everybody else is thinking or concerned about. And everyone has a fair chance then to respond to it and to provide you with information to try and either support or attack an application. Okay. And this is hard because, when your neighbors come up and they're worried about something and they're like, you're on the P&Z, you need to listen to me. The answer is, I do want to listen to you, but you need to be here in the room when we talk about it, or you need to put it in writing and get it to Nicole. Okay. It's something occasionally we forget about because we all are not lawyers or, we don't, this is not our full-time job. And in the event that you forget and you talk to somebody or you get an email from, your cousin who wanted to comment on this, the best thing to do is to summarize that to Nicole. Nicole can have a little write-up that gets put into the packet. Now everybody's on notice of what's going on. You shouldn't have to recuse in that situation. If you, however, receive a bunch of information outside of the public hearing, you'll likely be asked to recuse yourself in that instance, because that information simply can't be made available to everybody. All right, quasi judicial. The other thing you do, you make recommendations, code amendments, zoning, subdivision approvals. Those frequently are part of a public hearing process. And again, a public hearing again invokes that you want to get as much of the comment and information into the hearing itself and not happening outside the hearing. It's not technically a quasi judicial hearing because you're not the decision maker, but the best rule is to apply the same standard and to say, we want to hear what you have to say. Please come to our meeting. Please provide us information in writing. Okay. When you're making a recommendation, again, you're looking at things, you're looking at what the code says, you're looking at the information presented, you're merging those together, you're thinking through practical questions, you may be adding conditions to an approval, conditions that sometimes, Mark, or if I'm in the room, we have to get your feedback and then we go back and type something up and pass that out so everybody can review those conditions if you've thought of them at the meeting. And we're happy to do that. That's your prerogative under the zoning code or in the subdivision code to make a recommendation subject to approvals or subject to conditions, which then gets elevated up to the Board of Trustees, and they're the ones who actually make the final call on that. So those are generally the things that you do and the process in which you do it. Any thoughts or questions on those before we move on to some additional topics?
Yes.
Yes.
How does that work for us? When an applicant gets a approval or denial, either one, and then appeals to the Board of Trustees, can we then attend the meeting, as you suggested, and speak in opposition or in favor of one point of or another? And my question is just a little bit more specific than that. If there's an approval or denial, if there's a appeal to the Board of Trustees, and during that hearing, they do not present all the full information that they presented at the Planning and Zoning Commission, or they change something, or their interpretation of something some action that was held, can we then speak to the Board of Trustees?
You can, you don't lose your First Amendment rights simply because you are a member of the P&Z. And I mean that both in terms of the content of your speech and your right to petition your government to hear your concerns. What I would tell you though is that if you show up at a BOT meeting and you express strong opinions that could be interpreted as bias for or against a project, and that matter gets then sent back to the Planning and Zoning Commission for further review or for a subsequent approval that comes up, you may have to recuse because you've expressed strong opinions that could affect your ability to, again, hear the evidence and weigh it against what the code says. So you can show up at a BOT meeting. It does happen from time to time. I would encourage you to make your comments as not as a P&Z member, but as a member of the public. And I would encourage you to be objective with the comments as opposed to persuasive or argumentative.
There's a corollary to this. Didn't really write that down. I'll think of it.
Okay.
Go ahead with the next section.
All right, so we're going to talk a little bit about the procedure for the P and Z. It turns out there is not a lot of procedure in the town code that pertains to the P and Z. Code section 21670 says 3 members of the Planning and Zoning Commission shall constitute a quorum for the transaction of business, and that your alternates can substitute in order to get to a quorum. Because you are a 7-member commission, I was kind of shocked to see that the
Yeah.
quorum level was 3.
I've never seen that.
No.
Usually one more than 50%.
Yeah, that's what the code says. So you can conduct business if only 3 of you are present and don't have a conflict of interest. You will see a lot of what you do is simply a voice vote, motion to approve, a second, followed by, all in favor, aye, nay, and Nicole saying, all right, I think the ayes have it, and moving forward. What I would note is, and that's generally fine for running a P and Z. For more complex applications, Mark and I may from time to time present you with a resolution of the P and Z. And the only idea here is to try and get on a piece of paper the things that pertain to a more complex approval. And if you have additions or subtractions from it, it gives you something that you can kind of mark through and think through. Your decisions don't have to be memorialized by a resolution, but frequently that can, or sometimes that can help with moving a process along. So you will from time to time see a resolution from us. Getting back to voting, if you as a member believe that there was a miscount, in a 3 to 4 situation on a vote, sometimes someone doesn't hear something quite right, you can ask for a roll call vote, so that everybody has to say specifically aye or nay to the question that had been called. For purposes of procedure, again, a motion and a second and discussion and then calling the question is really it's pretty much what you need. You're not Congress or the state legislature. You don't need a book this thick with procedures and stuff like that. If there were ever something more sticky that came along, again, we're here to help you work through it. I would note that for continuances, for something that's been publicly noticed, that has to be continued to a date certain. And occasionally we see, again, where a hearing has been noticed and they're like, oh, well, let's continue that to a future agenda. That's not enough. You've actually got to continue it to a specific date upon which you have a meeting planned. Process, let's see. Just for an FYI, under state law, for you to conduct business, there has to be a written agenda, and that agenda has to be posted 24 hours in advance. Under the town's requirements, that's posted online, and I think we posted out in front of the town hall here. Work sessions occasionally, like I think you have occasionally a joint work session between the Board of Trustees and the P and Z. Those usually happen outside of the official meeting, although a work session is a meeting and it's open to the public. But a work session is to give you're not making a decision, you're gathering information for something that you'll probably come back and have a formal agenda item to discuss in more detail. It's a great way to gather information on reports. It's a great way to give, like, if we do a comp plan update, and you get the draft report and you've got a bunch of comments, it's a great way to work through comments from the board back to staff. So from time to time, you may participate in a work session. Again, just know those are public meetings. The public gets to show up. You're just not making a decision. And that means that the kind of the process is pretty loose at that point. Duties of the chairperson presides at the meeting. Lindsay, actually, you're a great P and Z chair from the observations I've had. You run a good meeting. You preside, you recognize people who are entitled to the floor to speak. That's both for members of the public as well as members of the P and Z. You regulate the discussion back and forth. You ask for someone to make a motion. You determine if more discussion is needed after a motion and second have been obtained. You just kind of make sure the meeting goes in accordance with plan, and you do a good job of that.
I have a question.
Yes.
I've always kind of heard, and I don't know if it's just like more decorum that like, and this is something that I have tried to abide by, is that like the chair themselves like doesn't make a motion. Which is why you see me just like staring at you guys sometimes. But sometimes, my optimism and just like wanting to move conversation along, that's like really difficult for me sometimes, but it is like traditionally the chair does not make a motion.
Correct.
then-
You do it well, yeah.
Okay.
Nothing prohibits you from not making the motion, and like with going into executive session where there's some specific verbiage we need to work through. Like with the mayor, when we do those kinds of things, he usually gets that motion out because he's got it all either written down or up in his head. But yeah, I think the better practice is by and large to look to your other members on the commission to make the motion.
Thanks.
I remembered my corollary question.
Yeah.
How are we to react when a member of the Board of Trustees comes before us and speaks?
Yes, well,
That happened last meeting.
And a couple before that?
I discourage the Board of Trustees from coming and making decisions where they are going to be the end decision maker. Now, on site plan, signs, fences, do we do shed permits? And so I can't
We do,
remember.
we do permits, but if it would just be a variance.
Okay.
Yeah, we do shed permits.
We do shed permits, okay.
Yeah.
Again, things where you're the decision maker, just like you don't give up your First Amendment rights, members of the Board of Trustees don't give up their First Amendment rights. And they can come and make comments as individual citizens. They're not speaking for the board, they're speaking for themselves to you. And but on matters that you're making a recommendation to the board, I think the best practice is that they wait and express their opinions once it's in front of them at the Board of Trustee level. But nothing stops them from coming and making comments. And I guess what I would say is you would weigh their comments the same as any other citizen who came in and presented you with testimony. Yes.
So what if the motivation is simply they're interested in the topic and they're interested in how like we got to our decision, and like they don't even, they don't say anything.
They just sit there.
Right.
Yeah.
Like it's almost just like altruistic. Like I want to see all sides of this situation. So like how did P and Z like get to this decision? To me, like that just seems so backwards that that's not encouraged.
Well, I wouldn't say that is not discouraged. The more challenging aspect is, again, if the board is going to hear the application after you make your recommendation to make the end decision, it's a quasi judicial decision for them. And therefore they really should be relying on what's presented to them in the Board of Trustees hearing. And that will include the notes from the P and Z and, information provided by staff about what happened there. They certainly can come and listen. They can listen to it on the website, nothing precludes them from doing that. It just becomes if they were to come and make a bunch of persuasive statements that would call into question their ability to objectively hear the application once it ends up in front of the board, that becomes a problem. So, and I don't think we've had that situation arise since this group has been, well, when I was here, we've had a few rocky times in the past, but those people don't seem to come to meetings anymore, so. Other questions? All right, let's talk about open meetings and open records. Open meetings are, so again, as the P and Z, anytime 3 or more of you get together and start talking about the public's business, or at least the business of the P and Z, you are engaging in a meeting that is covered by the Colorado Sunshine Act. And this happens less with P and Zs, but we have occasional concerns with boards and councils where, you know, you're at the park for the Saturday concert and you run into 2 other of your colleagues, and now there's 3 of you. And of course, you talk about what you have in common. Oh, you know, did you hear about what happened at the P and Z about this application that's coming in front of us? And that's a meeting. And they are precluded or prohibited by the Sunshine Law. So when you are out and about outside these chambers, you can get together, all 7 of you can get together and talk about gardening or the weather, or, you know, anything other than the business that's going to be presented in front of the P and Z. You just can't come together and talk about public business. That's prohibited. Public meetings need to happen in public places after an agenda has been posted so that the public has the ability to evaluate whether they want to show up and listen to what you're saying. So, another way in which public meetings can happen, which we don't think about, is emails. And the reply all function can be a real problem. If Nicole sends out an agenda with, you know, the packet, and one of you responds and says, oh, I read through, you know, the subdivision application and I have big problems with the following points, ... reply all. And then the next one of you chimes in and says, I read the same thing. I don't know how you're allowing this to move forward for our consideration and ... You now have a meeting going on. So no long email. Now, if it's about like, hey, we need to have a special meeting to consider an application, who's available Thursday at 6 p.m. That's not a public meeting. You're just coordinating. You can all be like, oh, I got, you know, scouts that night or whatever. That's fine. But for substantive discussion about matters affecting your business, don't do it on email. Don't do it on social media. And here's an example. There's the Silt forum. What is there?
There's Silt happens.
Silt happens. Thank you. You know, you and 2 others are members of that group, and someone starts to attack an application that you're going to hear, and the next thing you know, you're on there chiming in about what you think about the application, and 2 other of your members are reading this and maybe they're chiming in as well. Public meeting, don't do it. These are just these little ways that in our modern world we think of a public meeting. We come together at town hall, we sit behind the dais. In our modern world, there are other ways in which the Sunshine Act limits your ability to discuss the public's business. So, I doubt this is something that probably applies to you, but I encourage all town officers not to turn their social media pages into public documents by having discussions about the public's business on them, because you are appointed officials, and if you choose to, again, use your social media page for public business purposes, you may find yourself at the end of a open records request, wanting to get copies of your social media page as part of a request for government documents. Don't turn your social media page into a government document. Just don't do it. Makes it easier for me. So. We've talked a little bit about executive sessions and the attorney-client privilege. You have, as I've discussed, you have the right to receive legal advice. I'm not here every meeting. If you think there's something on an agenda you want to get legal advice for, please let Nicole and Mark know in advance so that we can make arrangements for that. Additionally, so we super majority to go into executive session. I guess this is another thing. What is discussed in the executive session is subject to what's called the attorney-client privilege. And that means that the statements and the discussions we have within executive sessions that are designed to give you legal advice on a legal topic, they cannot be compelled to be disclosed, whether in a deposition or the recording itself. It's the attorney-client, it's subject to the attorney-client privilege. You are my client. I give you legal advice. Nobody can force you to disclose that. What you need to know is that you also don't get to disclose what we talk about in executive session. You have to keep zip mouth about that because it's subject to the privilege. And under the charter, the only entity that can waive the attorney-client privilege on behalf of the town is the Board of Trustees. You don't have the right to do that as a P&Z. So what we talk about in an executive session stays in executive session. Yes.
Are you allowed to take notes during executive session?
Yes, but I would encourage you to hold them for the limited amount of needed time and then destroy them. Yep. All right. Open records. These are essentially any records that you maintain that are not subject to the attorney-client privilege, that relate to work you do on the P&Z. And your notes actually can fall into that category. I don't know that we have a records retention policy for the P&Z, but you know, if you keep those documents, if your natural habit is every week you're the neatest person and you shred everything that you're done with, well, that's how you handle those records. They're gone. But if you keep files on things and we get an open records request for all matters related to the XYZ annexation and zoning, we can require you to turn over your notes as part of an open records request. It rarely happens with the P&Z, I'll say that. With the Board of Trustees and with matters involving staff, it happens more frequently. So, all right. Minor item dealings with employees. I kind of put this down at the bottom. It's on page 3. You're not the boss of the community development department. You're an advisory and decision-making body that deals with them a lot, but you don't give them direction. You can provide them insights, here's 3 ways I think we could do things a little better. You can do that, but you don't get to give the community development department direction. In fact, there's a charter provision that prevents that from happening. If you ever did have a problem with an employee that in the community development department, your job or your requirement is to go to the town administrator and have a discussion. So, there are these kind of separations of roles. The town administrator is the head human resources person for the town of Silt. If there's an employee issue, go to the town administrator. Okay. All right, we're going to do a little bit of ethics here, conflicts of interest, and then we're going to talk a little bit about what's called the Code of Ethics. What is a what is a conflict? This is from the town of Silt has adopted an ethics code. There's also some provisions in the charter about ethics. All of those are pretty much based on the Colorado ethics statute. There's a state ethics statute. So it's a matter in which an official has a substantial personal or financial interest, direct or indirect, including an interest held through a spouse or family member, other than the common public interest, or on any question concerning his or her own conduct. It's a lot packed into one little sentence. So let's talk a little bit about this. Direct or indirect financial interest. So if you owned 50% of 25 Elm Street with your brother, and you desire to subdivide 25 Elm Street into 10 lots, you can't just have your brother process that application and still sit on the P&Z to make a decision. You have there a direct financial conflict of interest. Your daughter, and there are limits to family. Family is your parents, you and your spouse, and then your children. So your third cousin removed doesn't count as a family member in this situation. But if someone in your family has a financial interest in a matter coming in front of the P&Z, and even though you don't personally, you also have to recuse. You have a financial conflict of interest. If you know your daughter wants to get site plan review for a fourplex that they want to develop, you can't sit in judgment of that application. You have to step back. So you can have a conflict of interest because something disproportionately impacts an interest you have differently from the rest of the public. And I could see this being like someone has a subdivision coming in directly next door to your property, and they want to put a high traffic volume alley right next to your house. You have a personal stake in the outcome of that decision that is different from pretty much everybody else in the town of Silt. You would need to recuse yourself in that situation. But if your interest is not really that different than the rest, let's say the subdivision is up 16th Street at the top, and you live at the bottom of 16th Street, and there will be a few more cars that pass by your house, but it's going to be the same few cars that pass by all these other neighbors that live along that road. Yours is at that point kind of the general public interest, and you get to sit. Just because you might feel a little bit of impact from a proposed activity doesn't mean you have a conflict. It's when it gets closer to your specific property interest, or that you feel in order for your interest to be protected, you need to speak openly and not necessarily be neutral in the outcome of a decision. Then you have to step back from participating. You have a conflict in that situation. There is in Colorado, we created constitutionally something called the Colorado Independent Ethics Commission. There is a constant back and forth about whether what are called home rule municipalities have to abide by the decisions of the Independent Ethics Commission. Without resolving that as of yet unresolved question, I would note for you that the Independent Ethics Commission takes a very broad view of a conflict of interest, to where there was a matter brought to them where there was a realtor who managed short-term rentals in a community, and that realtor also was on the town council. And the town council was considering some limitations and, code provisions about short-term rentals. And the realtor said, oh, well, I deal with those. Maybe should I participate and submit an application to the Ethics Commission? The Ethics Commission came back and said, yeah, I mean, if you might have some more business based upon how you vote on short-term rentals, well, you got a conflict. I don't agree with the Independent Ethics Commission on this point, but just know that the more that it looks like you somehow are benefiting or your personal interests are being evaluated with a different weight than the general public, the better thing is to say, I may have a conflict on this. I'm going to recuse from consideration. So, and you do have a disclosure obligation whenever you have a conflict. That's why we have that on the agenda, to trigger you to think through that. Do I have a conflict on any of these agenda items? If you recuse for a conflict, it is only on the item you have conflict with. You're not disqualified from participating in all items on the agenda. For that particular agenda item, you can go sit out in the foyer and drink a cup of coffee and come back on the agenda items. So, conflicts, questions. If before a meeting you ever wanted to ask a question, might I have a conflict on this? Again, talk to Nicole. Nicole will reach out to me. We'll organize a call. We'll have a discussion about it. We're here to help you make good ethical decisions. So, all right, the final few items. Code of ethics. There are a few provisions that apply to you as officers. Gifts. You cannot accept a gift or thing of value in excess of $65 from someone who has business in front of the P&Z that would tend to improperly influence a reasonable person from being objective. So I know you get offers of gifts very frequently, but if a developer, before they submit the application, if they said, hey, I'd like to take you for coffee or for lunch to talk to you about your thoughts about how we develop this area over here, you can accept to have them pay for lunch as long as it's under $65. It doesn't come up very frequently. Doing business with the town. If you are thinking of applying for a contract or doing some work with the town, best to talk with the town administrator or myself about that before doing that. Because there are limitations on your ability to act as an officer of the town in business relationships with the town. Ex parte communications, we talked about this with quasi-judicial hearings. You need to have your communications within the public hearing. The attorney-client communications, again, you shouldn't be disclosing those outside of the executive session. Just be careful when you're discussing the business of the P&Z outside of the meeting. Just think through, is there an ex parte communication issue that I've got to deal with? And then confidential information, again, when it's attorney-client privilege protected, only the board can waive that. Occasionally, we might get some information as part of an application that is confidential under state law. Like if the federal government wanted to put a security facility in Silt, well, the drawings of how the security facility is put together, those are protected. It would be something we would bring up to you that, that there was confidential information, and while you might be able to view it, you're not allowed to pass that on beyond the P&Z or something. We'll handle it on a case-by-case basis. Equality of treatment, no official shall grant any special consideration, treatment, or advantage to any person Other than that, which is available to every other person. I mean, this really is, your goal is to try and treat the citizens of Silt equally under similar circumstances when they come to you. If a fence was appropriate in situation A, and generally those circumstances exist on parcel B should also get a fence. Shouldn't depend on who you know, should depend on what the law says, what the facts are that are brought for your consideration. So, glad we were able to do this. Took a little longer than we thought, but happy to answer any questions.
Does anyone have any questions for Attorney Sawyer?
Boy, no questions.
We had some during the meeting, so. Okay. Again, if questions come up, talk to Nicole. Nicole can get those to me. We can get you answers.
Great. Thank you so much. Appreciate it.
Thank you.
Happy to do it.
All right, are
Okay,
we
we
ready
ready
to
to-
move into our next agenda item? I also noticed that there were some folks that have joined us on the phone. Do we want to go back up to public comments and the consent agenda at this point? Okay,
Training and some other stuff, so.
we'll wait a couple
Which we
minutes
have
for
ready.
our guests to get seated. Hello,
Hi.
welcome. All right, so this section of the meeting is going to be devoted to public comments that aren't a part of any agenda items this evening. So is anyone here to speak on anything other than what's left on our agenda? All right, not hearing anything. Nicole, is there anyone online that wishes to make public comment on anything unrelated to our next couple agenda items?
I do not see any raised hands.
Okay. Next, we're going to move on to the consent agenda then, the minutes of the December 5th, 2023 Planning and Zoning Commission meeting. I'd entertain a motion.
I motion that we accept the consent agenda of the last meeting.
Second.
All right, we have a motion by Commissioner Doty, second by Commissioner Berteau. All those in favor?
Aye.
Any opposed? Nope. All righty. So then jumping ahead to what's next on our agenda is the Lestadian Church annexation with recommendation to the board. Planner Chain, this has your name written down next to it, so
Yes,
we'll
it
let you
does.
go
It's
ahead and
me.
get started. And we have our applicants who are up here as well.
And you may want to recognize that Miss Stepanik has recused herself from.
Thank you. Yes,
Yeah.
Commissioner
I was gonna
Statisnik
note it.
has
Okay.
recused herself from this section of the meeting for the record. Thanks.
Okay. Oh, you're already up there. Thank you. Okay, so this is a continued public hearing from November the 8th, I believe. And at that time, we went through the original presentation. I'll just recapture just for a minute or two. I'm not gonna go into detail on everything. I think we know where we are, but basically the church was asked to reach out to the neighbors and have a meeting or a get together or somehow look at their relationship to the neighborhood and some of the concerns that were voiced on November the 8th. So do I have control of this?
You can.
Yeah, just
Okay,
oh,
you're
and
up.
by the way, do I need to unmute myself or because I'm here?
The microphones are
everything's
fine.
fine?
You want.
Okay, so. Let me get back, and for some reason, everything went off here. Anyway, to make a long story short, Lestadian Lutheran Church of the Roaring Fork Valley, I always have, a bit of a hard time with that entire name. It's virtually a joint application between the church and the adjoining property owner, they're Jermuz, that's Matthew and Susan. And the church owns up there They own 3.008 acres. The Jermus own almost 7 acres. And the application is to eventually split off 31,000 square feet and add it to the western property portion of the church. And so the request is for one, to annex that property, two, zoning, and the zoning is agricultural rural. That's the zone district that does allow churches. And then the last item, as part of this, it's not in front of you right now. It's a lot split, should I say, yeah, it's a lot split, splitting off 31,000 square feet and transferring it from Jermu to the church. That is something that can be done at a staff level, and that will be done after the board hears the annexation and the zoning request. You're not talking tonight about that 31,000 square feet. The property right now, the property that's in the county is zone rural. That's 1 unit per 2 acres. And originally I talked to the county about this. I thought the proper procedure was the Jermus split the property in the county. And then when there's a lot split, then they come in for an annexation. First of all, that gets to be a bit unnecessary because there are 2 jurisdictions overseeing this. And the other one is that if they were subdividing under the county's rural zone district, the minimum lot size is 2 acres. The church doesn't need 2 acres. Maybe the Jermus don't want to give up 2 acres. Anyway, the application is for much less. This is cleaner. We have contacted the county and they will be a review agency about this. And one thing I do note is that the present property description for the church property actually proceeds 30 feet out into the county road right away. That's County Road 231. So at the end of the day, if that lot line application is approved as presented, that corrects that. And if I was own property, I wouldn't want it sticking 35 feet out into the road right of way just for various, hey, if there's an accident, everybody gets sued sometimes. You don't need that. So that will eventually clean that up. At the last meeting, I went over the development plan, or actually there is no specific development plan at this time. The church has indicated that it will be for some type of future growth. The church, and if I'm speaking wrong, you can correct me when I finish up. Right now, the church is growing organically, and they expect they'll be growing also in the future. When I've talked to them informally, it's about there may be a swap in some of the areas within the building, and then they would add on more. Basically, there's probably going to be an area where there's an eating room and maybe a facility for some events. And they will probably do that within the property boundaries of what they have right now. I mean, right now they could go in and have a building permit application to blow out the south wall, for example. They're not proposing that. At the end of the day, I mean, they really could go and build on this new portion that would be added to the property. Doesn't make sense. They probably want to have it all, connected. But that property may end up being, it could be a play area, it could be parking, it could be designed to hold outdoor events specifically. We don't know. And I'm not sure if they know yet either. And that's probably something that is changing as we speak. I did, at my last meeting, I made a finding that the application does meet the Silt Comprehensive Plan, and that designation for the property is agricultural, rural, residential reserve. And now get down to more of the specifics. At the last meeting, and I forgot to tell you, just to reconfirm, you are recommending body tonight for the zoning and for the annexation. You don't approve the annexation. That's going to be at the board a number of weeks from now. At the last meeting, there were some concerns raised by neighbors. And what has happened is that the church reached out to the neighborhood, advertised in a few different formats, and there was a meeting. The agenda for that meeting is in your packet, as also is their notes. And that's one of the things that we wanted to clarify and work out over time. So they've had that meeting. And what I have done is I have put together a resolution, which you could adopt tonight, and it has certain findings and conditions. And one condition that I recommended was that there'd be a site plan review for any new activity which would occur on the site, whether it be for building, they're expanding parking, whether they're building a new playground set. And you would probably get that in that zone district anyway, because this is, I guess this is more an institutional use, but with the town, if you get above 2 dwelling units, and if you also have any kind of commercial activity, that kicks in a site plan review process. So I think that is what would be happening in that zone district anyway. So what would happen if they want to add 1,000 square feet? It would come before the planning commission for a review. Is everything being mitigated that could occur with the neighbors? Is there support? What are the facts? And then you are the decision-making body for a site plan review. It goes to the board only if there's an appeal. I made a number, one thing I do want to update too, my initial staff report, I said that the water rights needed to be eventually dedicated to the town. And that is not the case because it's DLM water. Is that the proper term?
Saltwater Conservancy District.
Saltwater Conservancy District. That can only be used for designated property, basically for agricultural uses. So as long as that stays as some kind of open space or lawn or whatever, the water could be used for that. And I think that should be part of any annexation agreement. At the last meeting, I made a number of findings, and they were that the parcel from the Jermu property is eligible for annexation. The owners and the applicants have submitted an annexation map, a petition for annexation, and a zoning request that appears to be compatible with the comprehensive plan and the surrounding area. I stated there is no specific development plan at this time, but there should be site plan review process where there is oversight by the commission and neighbors have an awareness of the plan and ability to make comments. That an annexation agreement should be drawn up by the town attorney for review, and the agreement should take into account the transfer of appropriate water rights and provision for review of any future development plan. My recommendations: all representations of the application made in writing or verbally at meeting or in the materials are considered part of the application and are binding. That the property should be placed into the agricultural rural zone district. The water rights pertinent to the share of the use by the transfer parcel be used to irrigate the transfer parcel as long as it is used as open space, lawn, recreation, or other uses which do not include a physical structure or pavement. That any development of the transfer parcel or expansion of use on the presently owned LLC RFV parcel, including expansion of the existing structure, the construction of a new structure, enlargement of parking area, or any type of open space play area, be subject to a site plan review per section 17.42 of the municipal code, and that an annexation agreement be drawn up by the town attorney. I have a recommended motion there. I did put together a draft resolution just because this meeting was continued. I want to make sure that there was a record of it. It is in your packet. That should be part of any kind of motion. If you choose to recommend that the property should be annexed and it should be zoned as per my finding, that resolution, the town attorney has reviewed it. It was also in the packet for the applicants to review. And when I spoke to Darren Byman, towards the end of the year and the beginning of this year. And I told him that I thought it'd be best to include the site plan review process as part of the approval, so they should be aware of it. And with that, I am open to questions before you have the church make their presentation or update.
Great, thanks, Planner Chain. Does anyone have any questions for Planner Chain? All right,
I have just one legal comment to make, and that is that the inclusion of the language about the property going through a future site plan review if and when they choose to make modifications to uses and the configuration of their site. That is not, so that is supported by the language in the code. They probably have they have the obligation to do that anyway. We just thought, in light of some of the concerns that were expressed by the public, that it would be kind of a trust building exercise to have that in the resolution.
That's number 4 in Mark's planner recommendation.
All right.
great, thank you for that.
And by the way, just so in case anybody is watching, I see some people who are listed there and I don't know all of them. Here is the resolution, and it is on page 17 and 18. Actually, and the legal description is on page 19 of the Planning Commission packet. And oops, okay, I'm sorry. I thought I was on,
No, it's,
I didn't.
You didn't share your screen.
I will go and make this so, and I will share the screen here. I'm sorry about that.
pages 18, 19, and 20.
Pardon?
Pages 18, 19, and 20.
Yes, okay, there we go. And let's see, hope it's up there. Yes, here we are. And somebody is waiting to come into the meeting. So.
Thanks for that, Planner Chain. Before we turn it over to the applicants, I did want to confirm this is not, there's no public hearing associated with this agenda item this evening, correct? I didn't see that listed on the agenda.
Yeah,
There was a public hearing notice.
Yes. It was public hearing notice for the November meeting, so to me,
It
it's
was
a
continued to
continued
tonight,
public
so it
hearing.
is a continued public hearing.
Okay, gotcha. So that's not reflected on the agenda. It's like a public hearing. So just wanted to point that out.
It just, in terms of your process as the chair, you'll just take public
Okay.
comment. Yeah.
Sounds great. So we'll get to that after the applicant discussion. So welcome back, gentlemen. How are you?
Thank you. Good.
Great.
My name is Logan Jermu, representing the LLC RFV, and this is Darren Byman, the aforementioned Darren Byman. I think Planner Chain summed up the events that have taken place the last couple months pretty well. I wasn't able to be at that neighborhood meeting, unfortunately. Darren was and can maybe provide some specifics to that meeting. But what was discussed there is some of our possible development options. I know we've talked about not having a final development plan, but this annexation is part of that puzzle as we move forward. And so we don't want to dive into a site plan without having an understanding of how this motion might be carried. We've tried to make some good forth efforts on a couple of those items. One were the lights. We've taken action to turn those off, I think every night except for when we're there, which is Sunday and Wednesday evenings. We've offered to construct a landscape buffer or some sort of fencing in the future. That may be helpful. We're looking into some possible solutions with the actual lights themselves, pitching them downwards or whatever covering we need to take on that to help out there. Obviously, it's a conglomeration of people coming together. And so we are trying to make known the neighbors' concerns throughout the congregation, advising of those concerns, and then putting word out that, hey, these are some things that we want to work on. But I think Planner Jane kind of summed up primarily what's happened. I think from our last meeting, we were advised to hold the neighborhood meeting, and that's something we've done, and we would take any comments or questions from the commissioners.
I'll speak real quick. This is Darren Byman. So at that meeting, from the notes of the previous meeting, it sounded like maybe the neighbors were a little confused on what our intent was with why annex, why gain more land. So at that neighborhood meeting, we have been working on plans. So we did present our site plan sketch, which is very rough at this point, and then a possible building expansion going to the east, which would keep, as Mark said, everything that we're looking to build or expand. The buildings would be on the land we already own. So all of the annexed additional land would be for green space or preserving playground area, that kind of thing. But yeah, that was the biggest thing I thought was maybe some of the community was in the dark on what our intent was with the annexation. So that was cleared up. And then as Logan said, just reminders to our maybe especially our younger drivers too on some of these concerns with maybe being respectful and keeping our speed down, coming and going. And then the lighting, there was a couple areas of concern, which I don't know if we can really accommodate them, such as the drainage. Sounded like maybe one of the basements flooded from some incorrect drainage, which we don't know any of the details on that, but that's, obviously a final civil drawing would be engineered and, worked with the drainage system that's already in place going to the south. So are there any questions or any other comments?
Yeah, thank you. Appreciate that. Do any of my fellow commissioners have any comments of the applicants?
I do. The meeting notes represent some statements that seem to be kind of one-sided. You were taking the notes and providing them. Someone was taking notes and providing them to us. But what I don't see here is what was the give and take? What was the back and forth between your group, your church members, and the public members? What was that like?
Yeah, I didn't realize those notes were going to be the published notes, so I apologize for that. That was just strictly the comments or concerns from the neighbors. That you're correct, is one-sided. And as far as a larger group congregation, we haven't had a chance to publicly get together and discuss some of these concerns due to holidays and just kind of the timing of everything. But that is definitely on our list to do. But some of the easy things, like such as the lighting, we've tried to, fix some of that. But so I apologize for some of that just looking one-sided.
Well, did they seem to understand?
As in the neighbors?
Yes.
Yeah, I think we left the meeting knowing that there's, maybe a neighborhood concern that is over here, and here's what we're trying to achieve. And then somewhere in the middle is where it's going to be working together to figure out how this is, everybody's going to be happy. But I guess the concern, like the drainage, we may not have any control over that. One of the comments you saw on the list there is communication about public events. And we were kind of taken aback by that. We did have a couple weddings this past summer, especially. And I guess we didn't think to, notify neighbors that we're having a wedding, which, maybe there's a few extra cars, but whatever. I mean, if that's a concern,
I don't think you're required to make.
Right, exactly. But so those were just some of the comments that were brought up, but our website is public and anybody can find out what event is going on anytime. But, that's maybe one item where I don't know if we're going to tell them every time we're doing an event over a certain size? I don't know. But, you know, those were just some of the concerns.
I guess I'll just express a concern that I even felt at the last meeting that should you go to site plan review, you probably need to have an engineer look at the property and see if there's a way to solve or mitigate the neighbor's concerns as far as drainage. I mean, that's a kind of a good neighbor policy and should be, I don't know how much the law requires that. I mean, to what extent it requires, but I know that you do need to have an engineer look at your land when you propose a development.
Right. Well, I think it's required to even submit a drawing for a permit anyway. I'm sure this size of project with runoff for stormwater is going to require an engineered plan and definitely we did actually just get another soil report, which is a geotech engineer finding. We just recently got that, but.
Very good. I'm glad you answered it that way. So you're on record. That's all. That's all I have.
Planner Chain.
Something I forgot to note, even though it was in the staff report, is that as there were concerns about drainage and there are a lot of easements on that, you know, property boundary, you know, between Mira Loma and the church. I went out there with Nicole and also with the Public Works Director, you know, to try to figure out, well, my first thought was, well, you know, that hydrant up there, water hydrant is at the end of the dead end line and, you know, that needs to be flushed once in a while. Well, Trey said it really hadn't been flushed in probably 2 years. And then it was further away from the property boundary than I originally thought. It was more or less in the middle of I'll just call it their front yard, you know, to the south. So, and with the grading there, I'm not sure if they let that hydrant flow for a certain amount of time. I don't even know how it would go and get necessarily into some of the basements. I'm not sure if it's coming from somewhere else. I know years ago, outside of Carbondale, my basement was getting flooded and there was a ditch 100 feet away and we threw dye in there and son of a gun, you know, and ended up in our basement. Something's not right. And maybe it's how it was constructed, or maybe there's a ditch somewhere and there's a little hole in the alignment and it just migrates. But we did go out there and take a look, and I was actually hoping it was an easy fix. I was hoping that the hydrant was right near, you know, some of the neighbors' yards, and it's not.
There is a ditch directly north of our property that runs west to east. I don't know if that's, you know, we'll have to do our due diligence on that area for sure, like Mr. Bateau suggested.
I got a question. The geotechnical engineer, what was the requirement for him? What were you investigating?
We were investigating the soil where the proposed addition would go. So we would know what kind of soil conditions are there, so we can design our footers and foundation to accommodate those soil reports.
Okay, I'm just kind of curious.
So in part of their findings, usually they'll have a recommended drainage system for around the building, which I guess doesn't really impact the neighbors so much at this point, but definitely like a parking lot plan would.
Yeah, because a lot of times when they do their borings and soil analysis, they do come into the gravels and stuff like that. And you would see, you know, if there's a channel or something running through there that may be causing some of the seepage from the ditch that you're talking on the north side.
It would be, you know, intermediate between the ditch and the neighborhood to the south, where that boring would be located in there, but yeah, we'll do our.
Just curious.
Yeah.
Okay.
All right, are there any other questions of our applicants before we open it up to the continued public comment? No. All right, gentlemen, I'll have you go sit back down. Thank you so much. Might have you come back up here after we do the public comment, but we'll see. So the time's 8:15 right now. We'll go ahead and open it up to public comments per our Town of Silt procedures for public hearings. If everyone could look off to my right here, We are at number 4 on this agenda item. Public hearing is opened. You'll have 3 minutes to speak if you'd like to come up and state your name and address into the microphone. And then after that, the applicant may indirectly respond to comments made by those public comments back to us. So does anyone who's in here in person have any public comments to make? And then we'll move to the online folks.
I am Jennifer Stepiznik. I reside at 1744 Belgian Loop, a direct neighbor to the south of the church. And we did have a good, productive meeting from my perspective. I would like to encourage them to continue to build a berm with some landscaping on it to kind of block the almost essentially running a business in a residential area. So I think that, you know, maybe if they could continue to think about that would be great. But I do think that there has been an open line of communication just from the neighborhood perspective. So we appreciate that.
Thanks. All right, do we have anyone who is online who wishes to make a public comment? And if so, Nicole, are you able to see if anyone has their hands raised or needs to be unmuted?
Yes, if they'd like to raise their hand, we can take a peek here.
Okay, thanks.
I do not see anybody that is looking to make a public comment online.
Okay. So the time is 8:17. I'll go ahead and close the public comment session. And sorry, guys, would you mind coming maybe back up here for just a, yeah, thank you. Yeah, before we get to a further discussion or recommended motion from any of my fellow commissioners, I just do want to say, you know, appreciate you reaching out to the community and to the neighbors and hearing their feedback, and nice to see some of the changes that you have been able to do over the past few weeks with the holidays and the busyness of that setting in. But, you know, just looking at it from the perspective of neighbors being there for a long time and the church being there for a long time, and just, you know, maintaining that good neighborly relationship is, I think, is something that's important to this board. So it's nice to see that you're making progress towards that.
Yeah, not only important to you guys, but I think more important to us as well. So we'd like to continue to foster that relationship.
All right, does anyone have any other questions of our applicants? Any other questions of Planner Chain or Nicole, Attorney Sawyer? No?
I'd like to make a motion. Let's up one more page. I'd like to recommend approval of the annexation and initial zoning to the agricultural rural zone district with the findings and conditions. And I recommend that the Board of Trustees approve the annexation and initial zoning of the Lestadian Lutheran Church and the Jermu annexation with the conditions noted above. And any modifications or additions, conditions should be, no, there are no additional.
Thanks, Commissioner Berteau.
I'll second that motion.
All right, thanks, Eddie. So we have a motion by Commissioner Berteau, a second
Should
by
include
Commissioner Aragon.
Resolution too. That motion should probably include the resolution, adopting the resolution for the planning commission.
What, oh,
And
I
I did not put that in my recommended motion. That was a mistake. I have the resolution though. That's on, so you should also
Fine.
say and adopt
my motion includes that the,
PZ-1 series of 2024.
I got it. And my motion should include a recommendation to the Board of Trustees to approve the resolution number PZ1 series 2024. Do you want me to read the title? All right.
And I'll make a second on that.
All right, motion by Commissioner Berteau, a second from Commissioner Aragon. All those in favor?
Aye.
Aye.
Aye. Any opposed? All right, gentlemen.
Thank you for your time.
Congratulations. Yeah, absolutely. Good luck to you.
Thank you.
So Commissioner Williams, Nicole and I have conferred, and I don't think you need legal help on this fence item. Yeah, fence item for the next
That means you're
agenda
leaving?
item. I'm gonna leave, yeah.
Thank you for your time tonight. Attorney
Absolutely.
Sawyer. Appreciate you coming down.
Happy to be here.
Yeah.
We greatly appreciate the time you spend on behalf of Silt's betterment. Thank you.
Thanks, Michael.
We'll talk to you soon.
Perfect.
Okay.
Have a good night.
I want to talk to beginning of next week for,
All right, the next item on our agenda is Javier Caro. Tab D, Manager Centeno. You have your name next to this if you want to get us started.
Yes, ma'am. I'll ask Mr. Caro to come sit up in the hot seat here.
hot seat.
Hello, welcome.
Hello. Okay, Mr. Caro is coming in front of us tonight for a fence exemption. He is in an R2 zone district. He lives at 559 North 4th Street. This one is a little different. He did apply for a permit and it was issued under certain conditions. And then when it was inspected, it was realized that it was not built to the standards that was approved. And it deviated enough from the standards that was approved that he needs to come in and ask for planning and zoning permission to be allowed to keep it, because it does exceed the height limit and it is a hydraulic locking gate, which is a special use in our town code. You can see, Mark, can you give me the screen back?
Okay.
I think if you just stop sharing.
You want to stop sharing or I'll stop sharing? You ready?
Or you can go, that's fine. If you want to scroll for me, that's fine.
Okay.
So right there. So if you see the approved plans that are currently up on the screen, he was approved to have 42 inches along the side of the road, or, and the gate was not to exceed 48 inches. When you do look at his property, the elevation of his property is significantly raised. So he is adjacent to a street, which would need to be that lower, it can be 42 inches on the property line or 48 inches, 5 foot off the property line. His property line, it's hard to tell exactly where that sits. When you go out there, there's not markers, but his distance from the roadway is larger than 5 foot and elevated pretty significantly, as you can tell in the pictures on the following page. It is a steep drop off that his fence is sitting on top of. So I do believe that him exceeding the height limit where his fence is currently sitting would be an appropriate approval for the Planning and Zoning Commission. It does exceed the height by, so he was told 48 and the fence that is installed is 54. He also changed the what the material was that he constructed it out of. He had proposed wood panel fencing. It is actually plastic panel fencing. And then the gate is more along the lines of what the concern of the town was, that it is hydraulic locking. I did confirm with the Colorado Fire Department, the Colorado River Fire Rescue, and they definitely had concerns for emergency access. And so they have recommended, and the town staff would also mimic, that there needs to be a Knox box installed so that there is access. I did have the Public Works Department go out and verify the curb stop is outside of the fence. So we would have the ability to turn off utilities for non-payment in the future if it ever came to that, regardless of whether it was Mr. Caro or whoever he sells it to in the future. The hydraulic gate, it was discussed with emergency services and public works that there is probably a pressure point system in there. I am asking that I did not put in my, but I did put it, just not specified that he needed to provide full details of what was installed. We do need the system that he did install. We need that information so that we can vet through it if he is allowed to keep it. We have not done that up to this point because it would make no sense for us to continue to vet out the materials that were used or the system that was installed if he is not going to be, if P and Z is not going to allow him to keep the hydraulic gate or the fence that he installed. Overall, I do not feel that the fence and the gate that was installed, I don't feel that it is compromising other properties next to it or that it's obstructing anybody or on anybody else's property. I do feel as if we could approve this fence and the gate that was installed with the conditions listed on the staff report. I do want to reiterate, you can see on page, yep, right there, Mark. One more down. Oh, to the letter. You can see there is a letter attached in the staff report that in 2018, Mr. Caro had actually had previous communications with my predecessor, and it was determined at that time, and he was made aware at that time of what the fencing could be allowed, and that the fencing that was there, whether it was him that installed it or who he had purchased it from, that was exceeding the height. He did remove that fence. He still has the same concerns today that he stated, that was reiterated in this letter from March 9th of 2018. So given that this has already been a conversation that the planning and zoning has had with Mr. Caro and the previous community development director had also had with him, I would like to reiterate that in the future, approvals are to be abided by, and after the fact permissions will not be tolerated. So we need to make sure that it's asking for permission, not forgiveness, because that's what this is it's asking for forgiveness instead of permission to do what he did. I do have conditions listed that include, if approved, the applicant provides the community development department with a revised detailed plan of what was installed, that the fence be located entirely on the applicant's property and not installed in designated recorded easements, which I have not been able to find any recorded easements on his property that he is exceeding into or other property lines that he is exceeding into. I recommend that all recommendations or representations from the applicant made in writing, application materials verbally at the planning commission, he is actually not going in front of the trustees for this. Sorry, that's a copy and paste. Be reflected in the minutes and are all part of the application and binding, that the applicant will provide any additional requested documents and pay any remaining fees prior to the final fence permit being approved. And that all future fencing proposals will require a permit and fence exemption if required, that the applicant installs a Knox box key switch per the fire department's requirements, and that the fire department would also have to give that final approval that it was installed properly and that they have access to it. And that the applicant and any future property owners allow the town access to utilities and the meter if necessary. The meter is inside of the property. Technically, if that meter goes out per our code, the property owner would have to be the one to replace it. But if we did need access to it, we would need to gain access from Mr. Caro and potentially have access to the Knox box if needed. And I will open it up to Mr. Caro to fill in any blanks that he would like to add.
Okay, first, I want to say sorry because what I did. I did it because I didn't think it was gonna be a problem. I know I have to follow the rules, but at the same time, I was thinking it will be all right because my fence looks good. I did a great job. But yeah, I'm sorry. I didn't know it was gonna be causing a problem. Yeah. And also, what was the name of the other lady that was there?
Director Eloise.
Yeah, because at first when I asked for the permit, she told me that I can build the fence 42 inches. But she said if I wait till July, I couldn't.
Oh, you spoke to Dusty.
Yeah, Dusty, yeah. So I waited till this new rule was coming. So she told me to build it at 48. So that's what it is. My fence is 48 inches.
So,
It's not 52, it's 48 inches tall.
yeah, where I measured it was 40 or was
No, it's
52.
just 48 because all the panels are 48 inches.
Mm.
And the reason I did it at 48 because she told me it was fine. And then at first I asked I said I was gonna use wood, but then when I went to buy the fence, my wife decided to spend a little more money and make it look better. So that's why we decided to use the plastic. But believe me, I didn't think it was gonna be a problem. All I want is my house to look good. And then my neighbors, that they close to my house, they really like the fence and the way it looks. But again, sorry for what I did with you guys. I should have do exactly what you expect. So.
Thanks, Mr. Caro. Appreciate your comments. Do any of my fellow commissioners have any other questions for Mr. Caro? The situation that he finds.
But I'll be
himself in?
able to do whatever you just said. You have to remove it, or if I have to move the gate too, I will do whatever you guys.
Appreciate that.
Yeah.
Questions? First off, I want to make a comment if that's possible.
Absolutely.
Welcome to Silt. Glad you bought the property there that you did. Keep in mind also, the zoning ordinance is put into place to make sure that the community is organized
Mhm.
in a fashion that brings you here to buy the property that you did.
Sir.
Anytime you make an alteration to an accepted plans, it's a contract arrangement between the AHJ, which is the town, and you, the property owner. With that in mind, when there's any deviation, the town has to know it in order to make sure we're all in compliance with the zoning ordinance.
Hmm.
I thank them for bringing you into here so we can work on this as a team.
Okay.
And I hope that from the experience that you've had, any future things that you do.
Yeah.
Has to have, and it's again, under the zoning ordinances, is the plan
Yes.
that all towns use to make sure that everything is conducive to property values, yours particularly
Yes, sir.
also.
Yes,
With
sir.
that, my question to staff, boundaries. We're unable to determine the exact legal lot lines of this property.
Correct. When I went to go inspect it, I was not able to get inside the gate, which is what caused me to call Mr. Caro, and we weren't able to connect that day.
It's because we have a keypad outside the gate, so you have to press put a code to be able to get in. So that's what I was thinking, because I work in a house in Aspen, so we have the same same gate. And what we do, we just give the code to the police department and also the firefighter. In case of emergency, they know how to get in the house. And they also have a lock outside too with the key. So in case of an emergency, they can just go right in, like they can go in the gate.
And is that something that you have currently or something that you're?
No, I mean, I have only the keypad. So my plan was to give the code to you guys. I mean, you guys all can have the code, it's fine.
We don't
Well-
need the code, only the first responders do.
I just like the way it looks, and the only reason I put a gate is because, as you know, my house is at the dead end, right? So I don't know, this happened like 2 years ago. Someone came to my house and steal my car. And an officer of my house, the report. Someone steal my car from there. So that's why all this time we were thinking about putting a gate, because we don't want that to happen again. And also this, I mean, a lot of people, they go all the way to my house and they turn around in my driveway because they know it's their end. So that was part of the, I mean, what I decided to do, something like this, yeah. And as you can see, I did everything right. I used the right stuff. I mean, not what you expect, but what I'm trying to say is I did everything.
Yeah, absolutely. I mean, the
Good.
fence does look beautiful. It looks
Yeah.
very nice. I took a walk over there this past weekend, and you know, I
Mhm.
think you benefit from that elevation because it's not jarring, like
Uh-huh.
butted up against, you know, another fence line property that then there would be a discrepancy
Yeah.
against it.
Also, the water line is on the outside of the gate. There is access to get in, I
Mhm.
mean, to open the main water.
Mhm.
It's outside the gate.
Sure. You know, I think this commission's thoughts on it really have to do with, you know, what's in our code in the town. Obviously to Manager Centeno's point regarding just not really wanting to set any sort of a precedent regarding somebody doing something outside the scope and then just coming in and asking for forgiveness and us,
Yes,
you
yes,
know,
yes.
kind of being, you know, backs up against the wall a little bit. That's not a great position to
Uh-huh.
put us in, obviously. Can recognize that it does seem like it was you thought that you had submitted everything that you needed to, and it was a decision and a project that was made in.
Uh-huh.
good-
And I
good faith.
promise you from now on, I won't do anything without your permit. Believe me, the whole time I was thinking that it was gonna be okay. You know, I didn't think that I have to come through all of this and follow all the rules, like.
I think of what's of most immediate concern to me is the emergency services component of it. And if staff does feel like, just the inclusion, in part of the, what was it, the Knox box or the key switch, per the fire department's requirements, that's really my biggest concern, that
Yeah.
that gets, you know, rectified immediately.
Yeah, and it's not sufficient for him to just give us a code to access it, because that code could change at any point in time.
Yeah,
And then we wouldn't have that. So the Knox box would need to be required.
Okay, so maybe it's a little bit differently than how they do things further up valley.
Mhm. Yes.
Can I ask a question of staff? What is a Knox box?
It's a little holder that has like an override key that if emergency services came, they could access it without being locked out in any way. So he's gonna have to get with Orin Moon and figure out what is gonna be the best one to use that's gonna be compatible with what they're used to using. So he's gonna have to work with the fire department to make sure that he installs what is appropriate.
yeah, whatever
for
they
them.
need, I'll be able to.
Do you know how many like Knox boxes the fire department deals with? I mean, are we talking just in town or like county-wide? That, you know, the fire department needs those?
Yes, it's pretty common. There's a Knox box over at the town center that if they needed to access, or at town hall if they needed to access, it's really with a lot of the, especially government, community buildings. So
Gotcha.
they have them everywhere. It's something that stays stationary at that location that then they can access. And they have protocols set in place that it's, they have to access it in a certain way. It has to be called in through dispatch. It has to be, there's their override key that is part of that Knox box. So there's safety procedures set in place so that it doesn't ever become an abusive situation where people are accessing places that they shouldn't, but it gives them access for emergency services if needed.
If I can add to that also, it's red in color. It's a uniform standard by the FD and all responses to that. Commonality to get in, the emergency, the time is of the essence. So it's a recognizable feature that's in the industry, the fire departments, for all areas that have gates where they need to get into. Again, that's red in color and it's commonality used throughout the industry.
Thanks, Rob.
Add my 2 cents worth. Thank you.
Thank you.
Hey, Nicole, when you measured this fence, were you measuring the panels or were you measuring the top of the posts?
So it was both. So in my staff report, I put that it was ranging between 44 inches and 61 inches. The paneling, it is a little bit of a drop off, and it was, that probably could have been closer to the 48. Actually, I have my inspection sheet right here. So the gate is 51.5. The fence posts, the larger, like the posts on the outside, and between the paneling is 54, and the panels themselves are 48.
Okay.
And then the gate varies from 44 inches to 50 inches because there's just a lot of dimension there. So I was just doing the ranges of what the gate and the fence measured at. So when somebody installs a fence and it's supposed to be 42 inches, that includes, or 48 inches, that includes the fence as a whole. That includes the paneling, the posts, the gate, all of it is how it's deemed in code.
Okay, yeah, 'cause just looking at it, I mean, it looks like there's a slight incline there. So if you were to be flat, I mean, it may
Mhm.
be where it'd catch. So it'd have to be a little bit higher to, when it swings in or out. I guess it'd swing. I'm not sure which way it swings. so
For
if
the
it swung
gate?
in-
Jean,
Yeah,
But anyhow, okay.
and it's
Just
measured
curious.
from grade.
Yeah.
So anything retail, like, any measurements that are related to gates are from grade.
Makes sense.
And it is supposed to be street grade, but this is a very unique case. We're
No,
not
and
able to
I-
measure from street grade.
No, I see.
You would
It's
far
a
exceed
very
the
nice
height
fence. I mean,
limit.
it's very well done. I mean,
Yeah.
I have no complaints on it.
And it is a public meeting.
Oh, it is.
It is.
Great.
Yes.
Does anyone else have any questions before I open it up to the public meeting portion?
A quick question on the materials itself for the vinyl panels. What year is that? Like a 20-year type of fence, or is it 10-year? Is it? I mean, what type of materials? were
oh,
used?
this
Is
this
it-
material,
Yes.
it's very good material. It's for long time. That's the reason I use this material, because this is better than wood.
Yeah. Okay. I'm just curious to
Yeah,
make sure longevity. After 3, 4, 5 years, it don't start cracking and falling apart. So, yeah, just curious.
yeah.
Thank you.
I have a question. Did you install it yourself or did you have?
That's because I have a construction company,
Oh, okay,
so I did it myself with my guys.
okay.
So that's why every single thing in that gate is good. I put on these 2 columns, there's steel bars, 6 by 6. They're in the ground with concrete, everything. I built the gates. They're steel, and I just cover them with wood. So because it cannot be just wood, because otherwise they're gonna bend, right?
Right.
So
It's nice.
I also put a nice logo in there too.
Saw that.
All I need is all I want is just to to have a nice house and improve the town. I just didn't think much about this. I'm so sorry.
All right, well, it's 8:45. I'm gonna go ahead and open up the public comment portion of this meeting.
We do not have anybody in chamber to make a comment and nobody is online to make a comment.
All right. Hearing no public comments, it's now 8:46. I'll go ahead and close the public meeting. And if anyone has any other further discussion items related to Mr. Caro. Any comments before a potential motion is made?
I guess I'll just say that it's a great looking fence and it would look really great in Aspen. And a cedar fence would have been much more appropriate for the town of Silt.
I understand that. You're right. And I understand if you guys want me to remove it and do it wood, I'm willing to do it. I mean, we all have to be happy, right? And like he said, I mean, why not keep the town like they wanted it?
I'll go ahead and make a recommendation to approve of the Cairo fence exemption with the following conditions. That approve the applicant provides community development department with revised detail plans, what was installed. That the fence be located entirely on applicant's property and not installed on designated recorded easements. That all represented, should brought my glasses, representations of applicable made in writing, applicable materials and verbally at planning commissions or trustee meetings are reflected in meeting minutes and considered to be part of the applicant and are binding of the applicant. And then number 4, the applicant will provide any additional requested documents, pay any remaining fees prior to final fence approval. Number 5, that all fence features future fencing proposals will require a permit and fence exception if required. Number 6, that the applicant install a Knox box key switch for the fire department requirements. And number 7, that the applicant and any future property owners allow the town access to utilities and meter if necessary.
And then can I add, since I also did not add that to my motion, that you would approve the resolution? PZ2, I think I have it in front of you, Lindsay, off to the right-hand side.
Yes, which is this one. Resolution number PZ-2.
Yeah.
Series of
P-
2024.
PZ2 series of 2024.
Where is that at? Okay. Town resolution number PZ2 series
the
of
next
2024.
They go through the same thing.
We did.
Has Eddie satisfied what you need? What you're looking
Definitely.
for? Okay.
Yes.
So we have a motion with the resolution from Commissioner Aragon.
I'll second that motion.
We have a second from Commissioner Stepiznik. All those in favor?
All right.
Aye. All those opposed?
Aye.
Do you need any sort of roll call, Nicole?
No, it's pretty clear.
Yeah, okay, I think we got it.
Thank you so much.
The resolution passes. Yeah, congratulations,
Thank you.
Mr. Caro.
Thank you. Really appreciate it. And I promise from now on, I won't have any problems with me because I think I'm a good person and I like to do things right
Absolutely. We appreciate you coming in and
and be
owning
proud
up
to
and-
be here in United States because as you know, I'm born in Mexico. I was born in Mexico. So I'm very proud to be here in this country.
Well, thank you. Looking
Thank
forward to you working with staff to get a few of those items worked out and yeah, wish you luck.
Thank you so much.
Thanks.
Thank you.
So when you're available, come talk to me and we'll bring all of the materials
Okay.
of what was installed and we'll go through this checklist. So you can be in compliance.
Okay.
Righty? Have a good night. Thank you.
Thank you.
Thank you.
Thanks.
Alrighty, next on the agenda is the planner's report for Planner Chain.
Okay, I'll start even though I know that Nicole always has things to add. I thought I was going to have it done already, but I need to contact Mike Sorensen, who represented that Fifth Street application, the Coates lot split. Nicole and I, or maybe it's primarily I, think that we need an engineer to verify some of the information related to the drainage in the basement, what the drain is used for, et cetera.
This is the well
They
that
just
we
want
found?
they just want, someone TV'd it and they just want to cut it. And my comment was, so you just cut this drain? Well, it's not needed now. Well, how do we know that? How about if it is? They may want to come in front of the planning commission, so they don't have to hire an engineer, but that's something you'll probably hear about at the next meeting. Heron's Nest, I'm still waiting for updated maps from Schmeiser Gordon, my SGM now. But everything else is ready. Rislenda is going forward to the Board of Trustees at the second meeting in January. And they are talking to us about the best way to install a fence in front of the BLM property to help with that trail.
Cedar
segment.
fence,
Pardon?
a cedar fence would look nice.
Touche.
Rexon.
Actually, it's not a fence, it's a trail,
Okay.
but I've heard fence so much. I don't
I
know
was
if it
there,
goes
it's
that direction. And I was waiting for the motion to be a cedar fence, but anyway. 1421 frontage, that is the property next to Holiday Inn. And they are working on doing a multifamily application. Where some or most of the housing would be designed or worked through with Valley View Hospital. And they did come before the board for a quick discussion, didn't they?
They did, and the board redirected them to come back with something that has a little bit more fruition to it. And they are working to see if that's something they're able to accomplish or if they're gonna move on to a new location.
Okay, so they wanted more detail, the board did.
They wanted an actual, some sort of site, some sort of preliminary plan, because right now it's just a lot of verbal communication. So until they have something tangible to look at, it's not really worth their time to continue to try to discuss it.
Okay, all right, and then last but not least, there's River Run Storage, which I've been working with Ray Nielsen. And the application wasn't complete, needed updating. I gave him some formal comments back, and we still haven't got that new application finalized. It is better than the previous one because there is more landscaping. There still need some things to be resolved. And then speaking to be resolved, you want to talk about the other item?
They did receive their formal letter from the town with the non-compliant issues over there and the request to go through a site plan review. Even if it's not to the extent of a full site plan review that would have done prior, that we would have done prior to, it still needs to address the issues that were submitted to them in the letter that they received. They received that yesterday. We have not yet received a reply, but as that continues to unfold, we will keep you in the loop if we need to, and hopefully have them in front of you for some version of a
Yeah.
site plan review in the future.
Then we'll be looking at other things that perhaps may not have been installed yet in other parts of the project. So we intend to do a comprehensive look, not just where the small single-family homes are or where the storage may be, but have they complied with all other detail? Because I think there are a few that are missing.
There's several.
And that's the planner's report for now.
Hey,
I have a question. The letter that was provided to River Run that outlines kind of all of the issues. Would we be like privy to that, like at a time when it's deemed necessary that we would be looking at a site plan review? I mean, that's
Yeah, I don't think that's
Yeah.
privileged communication. That's
okay,
should
it
be
would be
public
public
record.
record, yeah.
okay. But it's not public record at this time.
I would have
Theoretically, it is.
to double check with the town attorney.
Yeah,
I think we probably are at a state in the process that you could do a public records request and receive that, but it would definitely be part of a staff report in the future
Okay.
when they're ready to come in.
Yeah, yeah, that will be included in the staff report.
I
There,
know-
there's nothing unusual in it. It's just, you were supposed to do X. You didn't do all of X. You shouldn't have proceeded, and we need to resolve this and come in and talk.
Mhm.
I know at one point when we had talked about it during like a joint meeting, it was kind of a little abstract in terms of what like specifically it was. So it would just be nice to know like what specifically we're asking them to come
Yeah.
back before.
Yes.
So-
It's not new stuff. You know, we met with Ray about some of these issues back in July, I think it was.
It
And,
was a while ago.
What's happening is that we think that River Run is sort of playing the town and the homeowners against each other, saying, oh, you could do it, but the town doesn't want you to do it, or yeah. So I don't think we're being treated fairly either.
Trey and I did have a meeting with some of the community members at River Run,
Yeah.
and they were able to give us more of a list of what they felt the problems were, or issues that they're having, that town staff had actually not thought of, that probably would have come up in a plan review.
Is it an HOA?
No, it's a PUD. So
Okay.
they do have a property management company
See,
helping manage the property. And I think that's where some lines are just getting crossed, where there's information being released that was shared with me by a property owner. There's information being released to the property owners that is highly contradictory of what the reality of the situation is.
Yeah. But
So-
yeah.
It's just gonna be education. We're just gonna have to get through the process and educate the homeowners over there on what the reality of the situation is, and just kind of figure it out as we go.
But Mike's question was interesting because he asked about an HOA. And there probably is an HOA within Camp Colorado, which is the RV park. It would be a separate LLC, which would own the storage, and then there's a group, LLC Variant, I think, which owns where the single family homes are, but you don't own the land underneath your home. You're a leaseholder. It's like a mobile home park. So there is an association of owners, but they don't own the property. So it's sort of an in-between thing. Anyway, but that's another wrinkle which affects things.
And then I wanted to highlight, we did have some community members reach out about questions with Family Dollar. I did add in my staff report for the board yesterday, and I'll just read that to you and I can answer any questions that you have. There are two different entities and permits for this project. One construction company is building the shell. The permit for the shell of the building was issued on February 1st, 2023. Another company is completing the tenant finish. The permit for the tenant finish was issued on January 2nd, 2024. There were several delays in the shell permit, which have included but are not limited to work being completed without a permit, unlicensed contractors, failed inspections, or inspections not being called in for. There are several remaining corrections that need to be addressed before the shell certificate of occupancy can be issued. The tenant finish contractor started work without their permit and received a stop work order. They did have unpaid tap fees, permit fees, and unlicensed contractors on the job. There were also corrections to the shell that needed to be addressed before the tenant
This is
finish
a
permit could
nationwide
be issued.
organization.
After working with the general contractor for over a month of the tenant finish, all requirements were met and town staff was able to issue the permit. A Family Dollar representative did confirm that the tenant finish would be complete in about a month. And as long as their inspections are approved and go as planned, the store should open sometime in February. So I know there was a lot of rumors circling around as to what was going on over there. I just want to make sure that there's accurate information getting out to the public and to our elected officials and appointed officials.
So there were concerns about why it isn't being finished?
Why is it progressing?
Yeah,
Why is it just sitting there and there's no action?
Right.
yes.
Yeah.
And Ed didn't have this all straightened out?
Rob wants to buy cornflakes.
No. Okay.
So if you have any specific
revenue,
questions, I'm
revenue.
happy to answer them. Otherwise, that's a brief update on where that project stands.
That's really frustrating.
So people aren't doing they aren't getting their permits, or they're doing something different.
Yes.
Or here's a letter from Janet. Oh, well. Oh, gosh.
Our BI caught all of that? All these infractions or felonies, as I would call them?
A combination of efforts caught all that.
Good, thank you. Good job.
Good job. Yeah, it's, wow.
There's a lot going on over there.
Absolutely.
And then River Run, the last certificate of occupancy was issued on December 28th. All 70 units are complete. The project as a whole is not signed off on because of the issues that they need to address of non-compliance, but all of the 70 unit single family structures are complete and CO'd.
Wow.
And from what I understand, they have all been sold or are in the process of being sold and closed. So I think they're all gonna be occupied.
So there's no hammer. They could just go and, with the exception of the storage.
And can you remind me, are short-term rentals of those entities prohibited? Or are they allowed?
They are going to be prohibited. Since there was not a site plan review, that is on the list to address. And if it is beneficial, I can go through the quick rundown list that is in the letter.
Sure. I mean, just for like a minute, no need to spend any additional
Okay.
time on that.
I'll grab it here. I will continue to talk about River Trace as I'm grabbing that. River Trace does have 2 buildings that are CO'd, 2 apartment buildings that are CO'd. And they have 3 more that have, that they picked up permits for that they've broken ground on. And then 1 more that they just picked a permit up for. And they have not broken ground on that one quite yet, but they are progressing through that. Camarillo is at a stopping point for the winter because as they're laying infrastructure, the compaction of the soils with the moisture is going to change between now and then. So they're going to have to, they had to find a stopping point so that they can make sure that they're not, the contractor stated that he is on the hook for this. So he's not going to do anything halfway. And he wants to come back and make sure that he's not going to work in conditions that are going to compromise the integrity of the infrastructure of the whole development. So they are at a stopping point until it warms up a little bit more and then they'll jump back on it. But they are still planning on hopefully pulling permits mid to late spring and then breaking ground shortly thereafter is their plan.
Do they have all their erosion control and everything set up around the site? I've seen a lot of stockpiles and stuff, so I didn't know if they had, silt fence, wattles, all that good
They
stuff to
do
make
have
sure.
silt fencing on the Grand Avenue side.
Yeah.
I think that there might be silt fencing up on the West Orchard side, even though it's not a through street. But they did request a release this week, and with the inspections that took place, the release was denied until they button up a couple things. So Public Works went out and made a list of things that they need to complete before an additional release can be approved.
Gotcha. Good.
As far as what is being addressed over at River Run, it's fences and the gated entrance, sheds and outdoor storage, landscaping, the number of vehicles allowed per unit, the open fire pits at the Cabin Village and the KOA, road widths and traffic flow as it's a single entrance, and emergency vehicles need to make it through, enclosed porches, carports, designated snow storage, and making sure that that snow storage does not obstruct fire hydrants anywhere. Address drainage issues in retention pond standing water, paved roads and directional identification signs. Dumpster location needs to be identified, cluster box location needs to be identified and installed. Address occupancy for the cabin village, short-term, long-term, owner occupied. Those are things that we need to address and figure out what is gonna be allowed over there. Then proposal to mitigate non-compliant outdoor storage, because there is a lot that has been done over there without a permit, that if it's gonna, it has to be consistent. So if this is not gonna be allowed, then whoever did stuff without a permit is gonna have to remove it, and that's up to them to help mitigate that. Compliance with the conditions of approval of the PUD, which include the public river trail. That is something that we had conversation about, is there's no trespassing signs, and there's signs that say this portion of the property can use this portion of the property can use that. It was approved that it's a public, it has to be connected the whole length of the property, it needs to be paved, and it's open to the public. So there is no, you guys can use this, you guys can use this, anybody can use any of it. It is open to the public, and access has to be open to the public. So that needs to be addressed. And then recreation vehicles that are in the KOA section being parked there year-round with propane tanks that are not approved by the town, larger propane tanks that are being used to heat, a long-term rental in the KOA, which is not allowed. And then we'll address the short-term rentals in the cabin village that that wouldn't have been approved through a site plan.
Great.
So that's a list.
There's a few little,
For
little
pulling
little
that up, I
ones
appreciate
too.
it.
Yes.
Like the dog park is actually a retention
Yeah.
retention pond, and then they did have representations of common areas and hot tubs and perhaps even pickleball courts, and
Mhm.
there is none of that. And I understand it. When you have a sketch, things change. Areas are modified, but
Yeah, that's why it's just important that we make sure that they're going
Yeah.
through some sort of site plan review process, because those are all things that would have been addressed prior to. So that is what we're working on with River Run. And again, they'll come back in front of you at some point here with
Asking for forgiveness.
addressing, yeah, addressing all of the issues that I just read off to you, and probably more. That was including but not limited to, that was a short list, but we have additional items as well.
Thank you, Nicole. I appreciate you pulling up that.
Yes.
as a
the
matter of
late
fact, here
hour
is the
review.
letter, which, you'll see sometime or other throughout the process.
Got it. And then other than that, I don't believe that I have any additional updates for you all. We're kicking off the season strong, and I almost have the event calendar done, and that'll be posted soon. Our first event will be the Easter egg hunt on March 30th. That's gonna start to get advertised, even though it feels like it is way too early to start
winter.
thinking about Easter. I did place Easter egg orders yesterday, so it's early this year.
It's early.
Yep, so that's
you.
coming up before we know it, and
Thanks for all your hard work.
I think that's all we have for planner updates.
So, any other questions before we move into commissioner comments? All right, round robin, anyone have anything for the good of the order?
I have one, the underpass sign access under I-70. It's laying on the ground and has been for about 2 months. So I
Okay,
just thought I'd mention that. I don't know if it was run over, blown over, or whatever. It's just laying on the ground. And it looks to me like it's still open.
Would that
Okay.
be CDOT's jurisdiction?
there
I know
are
what
a
he's
total
talking
of, I believe, 5 signs, including that one that has been reported to CDOT, that we're hoping they can get somebody out here to,
Well,
To
at least somebody hasn't
fix
stolen
those.
it yet.
Yeah. Well, that's true.
Yeah.
Yes, you're right.
yeah.
Silver lining. Thanks for that, Michael. Appreciate you keeping your eye out. Anything else?
Move we adjourn.
Second.
Alrighty. All right, guys. Thanks for your time
Thank you, guys.
tonight.
Sorry for the long meeting all. I appreciate you guys hanging in there with us.
We're supposed to be finished at 7:45, weren't we?
Tell me about it.
I don't know.